Thank you. Good morning.
SJC-11326, Commonwealth versus Melendez. Good morning. May it please the Court, Wendy Murphy on behalf of Appellant. I'd like to suggest as an overarching observation that perhaps the clear error of law here on appeal from a single justice decision filed initially under Chapter 211, Section 3, is that the single justice cited two cases that really do not control, and she cited only two cases, Hagan and McDonough, both my cases. And I'd like to suggest that her clear error of law includes that this is not a case, as those cases were, where the victim seeks to control any aspect of the criminal justice process. Quite to the contrary, the victim would like to have no authority whatsoever, but she was dragged in, if you will, through the authority of the court's order issued in connection with the sentencing decision, which not only gives her standing, frankly, but compels her to assert standing, because the real question, respectfully, is not did the victim seek to control the criminal case, but did the judge have authority to issue the order that then bound the victim in a 16-year legal relationship with her attacker.
Explain to me how the judge's order bound the victim to the defendant.
Well, among other things, the mere issuance of the order creating a 16-year window, if you will, within which the criminal defendant must participate in family court proceedings necessarily binds her because she has no choice but to participate. In other words, she can't reasonably not appear in family court without facing substantial risk of loss to her constitutionally protected rights, not to mention loss of custody of her child, if that's the result. In other words, by her non-participation.
How did she get dragged into family court?
Well, the order itself is the thing that dragged her in, Your Honor. The criminal judge's sentence included an order that there be a declaration of paternity and that the defendant in the criminal case comply with all family court, probate and family court orders for the next 16 years. The single justice expressed concern that the order wasn't directed by name at the victim. But that's of no consequence because the nature of the family court proceeding necessarily compels her to participate. So, it's sort of like, and I mentioned this in my brief, what if the order compelled a criminal defendant as a component of his punishment to submit to probation under the control of the criminal court, and during the probationary period, he should go and paint the victim's house a certain color. Yes, it's not an order directed at the victim, but she certainly stands to suffer the consequences of that order directed at the defendant. So,
well, let's assume there were no order by the judge. How would her life be different, apart from the fact that she would not be able to have the potential criminal sanction be available to enforce any probate and family court order to her benefit?
Well, the impact on her life, I think, is profound because, number one, the issue.
Try my question. How would her life be different if there were no order issued by this judge on the criminal case?
She would be unrestrained from the order compelling her to participate. And that is. And
where do I? Maybe I missed it. I don't know that. I don't find any order of this judge compelling her to do anything.
Well, as I just suggested in response to Justice Cordy's question, the order compels her by virtue of the fact that she has no choice not to participate because of the consequences associated with non-participation with regard to not only her freedom. She has no choice at this point but to participate not just once but for 16 years in an ongoing family court proceeding that would not exist but for the criminal court's order. That's essentially her freedom in the most basic sense under Olmstead and and Griswold and so forth.
Well, wait a second. Wouldn't it have been that he was ordered to acknowledge his paternity? So he just has to go and file a form. If he sought visitation, that's not ordered. It's not clear. Didn't she start the probate and family court proceeding?
Yes, and there's an indication in the record, and it's before this court, that
She got misinformation about that.
she was told she had no choice,
But
Your Honor.
that's not the Superior Court judge's doing. That's not a result of the
indeed it
Superior
is,
Court.
because she was instructed by the probation department on behalf of the court's order to go to family court, and then when she got there...
I see that as being, perhaps collateral, but having nothing directly to do with the Superior Court judge's order.
But the probation department instructed her that it was mandatory, and when she appeared at the family court, having been told it was mandatory, she was then instructed to fill out the forms. She wanted nothing to do with family court, but was compelled by government action in the nature of these instructions, if you will. No one said to her, you don't have to do this. She was told she must. And in a sense, it's the order itself that's the injury. I'm sorry?
Could she drop it, dismiss it?
In theory, yes. However,
this is an order for visitation, not for visitation, and the order and specifically says that's not what this order is about. So the order is about child support.
Well, the order is about...
If that's what she's seeking.
The judge's language was not so narrow. The judge did not say, only go to family court and only pay child support. The judge said, go declare your paternity and comply with all the orders that come up for 16 years. I understand that there's a sort of simple answer. It appears simple.
That is in the same clause as he's to support his daughter financially and abide by any support orders.
Right, but that's one among many other
and any
opportunities.
Restraining orders, and that's it.
But the criminal judge not only granted issued a very broad order, he has no authority to restrain what happens at family court. So if he sends the guy there and he declares paternity and undertakes to do all sorts of things, control the child's education, control where the mother moves to, and so forth, that's going to happen. The criminal courts, even if the criminal court judge explicitly limited his order, he has no authority to control what the family court does, and that's part of the problem. She could, and to answer your question, she could, I suppose, withdraw what she's filed. However, that misses the point. The point is the order itself is invalid, and the injury is the issuance of the order, not unlike what this court did with the GPS case, the Connolly case in 2009. It didn't matter whether the law enforcement officials were taking information from the GPS tracking device. It was the issuance of that control that created the injury, the legal injury, that then provides for the standing to make the argument that this is government power that is unjust and unlawful.
Tell me how it would be different if there were no such court order and he, the father, were independently to go into probate court and start a proceeding, declaring his paternity just because he wanted to. And she would be at risk of just the same kinds of things you say she's at risk of now, because orders could issue that she wouldn't like if she didn't participate.
Indeed, Your Honor. There's no question if the defendant of his own volition, simply because he's a biological parent, if you will, if he'd filed, we wouldn't necessarily be here, at least not yet, because we would have no choice but to litigate the tough questions: what rights do convicted rapists have when they create babies through the crime? But the fact that that's a separate question doesn't ultimately resolve the one that we really need to address here, which is, did the court have authority? And certainly because of that fundamental question, it really doesn't get us anywhere to say, well, he could have done it anyway, because I agree he could have. And there's no guidance out there. What might have, in this state and in most states, what would the law say if a convicted rapist did seek and file, as he has the right to do, for visitation or anything else with regard to his child in a family court case in a proceeding like this? The problem is not Would her life be different if he had done that? Perhaps she would be subjected to some of the same conditions, but that's a private actor filing an action in family court. This is a government decision to control a victim's life for 16 years for no legitimate reason beyond that the judge sought to impose these conditions on a convicted criminal. And it's fine if the judge, I'm sorry.
No, please finish.
No, my point was simply, I can understand the judge was well-intentioned, wanting to have some financial support for the child throughout the child's minority. But there was another alternative. The judge could have, and frankly should have, ordered it as a matter of restitution, which would have been appropriate, and we'd be in this same situation, but without the constitutional encroachment.
My question quickly is, I think, is there a subtext, and is it inappropriate that the judge, in granting, in ordering 16 years of probation, did so in light of the fact, although as you say, and it's accurate, this is a convicted rapist, it's a statutory rape, and the child was born of a union where these two young people were living in the mother's home and had a relationship, admittedly resulting in a child, and that is statutory rape. Does that play into it at all? Should it make a difference? Should there be a difference? Was that inappropriate?
Well, first, if due respect, this was not a relationship. He was 20, she was 14, and he was quite predatory toward her. So this was not a relationship. But in a case, let's say 14-year-old becomes pregnant by a 16-year-old boyfriend, would it matter? I think the answer is, in a moral sense, it might, because perhaps there would be less of a feeling of offense by the victim that she's compelled to this 16-year relationship, but it would still be would still have the same legal problem. It would still be unconstitutional for a criminal court judge to compel the creation of a family court proceeding. We might feel a little bit less bad about it, but it would be the same exact constitutional dilemma.
Your time is up.
Thank you.
Good morning. Larry Tipton on behalf of Mr. Melendez. I'll be brief, Your Honors. I think that the lower court, Judge McGuire, disagrees with the appellant's argument that there was any compulsion here. I believe that the single justice disagreed with the argument. I believe that the issue here is whether the single justice abused her discretion or committed clear error of the law. The appellant keeps trying to distinguish Hagan and McDonough and the other cases. But what those cases stand for is this clear ruling of law that a victim has no standing. And the cases that the appellee cites in his brief make that clear, that the issue here is one of standing. The questions that have been posed to the appellant here are actually exactly probably what the single justice was thinking about. This complaint that originated at the hands of the appellant. The complaint could always be withdrawn. The only thing Judge McGuire did in the lower court was issue an order that required my client to simply acknowledge paternity.
Could you address the hypothetical posed by opposing counsel as to the judge's authority to issue an order, for example, that would require the defendant to go paint the victim's house as a condition of probation, whether or not the victim wants that to happen? Does the victim have standing to say, I don't want my house painted?
I don't know that the victim has standing to say, I don't want my house painted. I think what the case law would suggest and what the Victim Rights Bill suggests, 258B, is that the victim would have a right to be heard and say, I don't want my house painted. Here, the victim did have a right to be heard during sentencing. There has been no argument made that any provision of 258B was violated in this whole scenario of the imposition of the sentence. I would state that it's very clear that on September of 2011, the sentence was set forth and laid down. However, it wasn't imposed until February because of the remaining issues regarding GPS and registration. All during that time, there was never any argument made that the sentence of 16 years probation and the requirement that the defendant acknowledge paternity, which he readily agreed to do, was a problem. So to answer your question, I believe that the victim might not have any legal standing to say that I don't want my house painted. However, I think the Victim Rights Bill gives her the right to voice that through the Commonwealth. And I would say that Judge McGuire did exactly what the judge did in Hagan that was observed in the Hagan decision. While the victim doesn't have standing with regard to the prosecution, the judge in this case gave the victim an opportunity and addressed the first motion that was filed in the trial court raising these issues.
Well, going forward then, for the next 16 years, could the father file for visitation?
Yes, in the probate court, the court with the jurisdiction of that issue, if he could. There's, as I say in footnote 5 of my brief, I know of no case law that would prevent him from doing that. In fact, 209C, the probate statutes, do not prevent him from doing so. But what is a matter of record is that he did not institute a complaint for custody or visitation. But he could,
Yeah.
Judge. But he could, not yet.
Is there a
but he could.
restraining order?
There is. That's all I have to say.
All right, thank you very much.